Begin now. So, hello everyone. Welcome to our webinar. My name is Jeff Smith, and on behalf of the Dispute Resolution Board Foundation, I welcome you to our so-called Fireside Chat. But here in France, where I am, it's 27 degrees, so sitting beside a fire is perhaps not the thing I most want to do. So we are having a chat with Enzo De Laurentiis, Chief Procurement Officer of the World Bank. Also here today is my fellow member of the DAAB and very experienced DAAB practitioner, Aisha Nadar. Now, we are very honored and grateful that Enzo accepted our invitation to speak to us today about the World Bank's SH prevention mechanism and the special role that DAAB members have to play within that mechanism. We're also glad that so many people are able to join us today. There are about over 200 people registered. So before we begin our chat, would Enzo and Aisha like to introduce themselves and say a few words?
Yes, good morning, everybody, or good evening, or good afternoon, depending where you are. Pleasure to be here. My name is Enzo De Laurentiis. I'm the Chief Procurement Officer of the World Bank. I'm responsible for what we call operations procurement, which means all the procurement that is done by our borrower, but following our policy, our rules, and with our close supervision, and even hands-on support increasingly. Thank you.
Thank you, Enzo.
Hello, everybody, and I'm Aisha Nadar, and it is absolutely a privilege and a pleasure for me to be here with Enzo and Jeff. I am the DRBF representative, country representative in Sweden, and it's a pleasure to have this conversation with Enzo today.
Thank you, Aisha. So to get started, Enzo, could you tell us firstly what we mean by SEASH? Because that's the key to the whole thing. If we don't know what that is, we won't understand anything else.
The acronym means sexual exploitation and abuse and sexual harassment is a terminology that is used by the United Nations. So for consistency, we also have adopted it. But basically, the objective is the prevention of every form of gender-based violence, right? So it's a specific terminology, and of course, there could be a long conversation exactly on type of examples, but it's a quite broad, and it really addresses a range of gender-based violence type of problems.
Okay, thank you.
Enzo, you mentioned gender-based violence prevention, and that's the objective of SEASH. So with that, how can you give us some idea of how the World Bank became involved in gender-based violence prevention?
Certainly, Aisha. So first of all, the World Bank in everything it does has one of the key objectives is the protection of the communities that we serve. So that is an overarching objective, and the prevention specifically of sexual exploitation and abuse or gender-based violence has always been a top priority for the bank. However, about 5 years ago, the issue was brought to the fore in a very dramatic way due to some tragic incidents in one of our projects, a transport project in Uganda. And it was also the subject of a review by our inspection panel, which is our independent accountability mechanism that basically reviews how the bank complies with its own policies and initiates reviews based on complaints by members of civil society. So these made it clear that although we always had this as a key objective, we needed to do better with our processes, with our approach to how we dealt with survivors, and the bank moved very quickly to appoint a independent panel of experts. And I'm really honored to be here today with you because you were one of the key members of this panel and a key advisor to us and to me personally on how to develop a strategy and an action plan, which was discussed and endorsed by our board. And it's quite broad, includes a lot of different aspects, all centered around the protection of survivors, but also addressing the way we help with mechanisms to present grievances, how we deal specifically to protect communities, but also this is more relevant to our conversation. There is a significant part of this action plan which focuses on our processes, on our operational processes, and within that, procurement, of course, is key, because it really relates on how contractors have to become accountable partners, to use the words of the independent task force, in helping the prevention. And they have emphasis on both partners, because contractors and good contractors are key to deliver good results, but accountable, because they're also partners in ensuring that we protect the communities and we achieve this broad range of objectives that are not just the quality infrastructure, but also again, protection of the environment and of the communities. So we have done a lot of work to raise the bar significantly in our requirements, both in terms of qualifications for the contractors and in terms of remedies within the contract. And the last piece of this was not only to ask that the borrower and the contractor manage very, very closely this risk through the process, but also to ensure that we had a credible mechanism to hold them really accountable, meaning if the contractors do not comply by their obligations, they can be actually disqualified by the bank. So this is actually was the last piece of this work, which lasted a couple of years, and the World Bank was the first, and I believe the only at this point, global institution that has such a mechanism.
Thank you, Enzo. You mentioned there about the exclusion of contractors and subcontractors from further work. Can you say more in detail about how the mechanism is to work?
So it's very important to first remember that the World Bank is not a party to the contract between the government and the contractor. We don't have privity to this contract, to use a legal term, because the borrower is responsible entirely for implementation. However, as I mentioned at the beginning, speaking about my role, we have a very significant role in ensuring that the borrower comply with our requirements. And one of the requirements is that the contract, in fact, is applied as intended. And is intended, among other reasons, to ensure the protection of the communities. So we were thinking how to develop something that would not be akin to a debarment, because it would be a very different type of qualification required to conduct those investigations, but also a different role, because in that the bank has a much more intrusive role. Here we wanted to ensure that we had something that was entirely contract-based. Basically, the parties agree to a mechanism that is rigorous, is credible, is already mainstream in industry, so it's widely accepted, and gives both parties, but also the World Bank, a high degree of confidence that the finding of this mechanism are, a good basis for the bank to make an independent decision, right? So separate, the contractual mechanism was set up in a way that relies entirely on the Dispute Adjudication and Avoidance Board, which you all are very familiar with. And the reason why we chose it is precisely because it's one of the very good tools that the FIDIC contract, and particularly the 2017 suites, gives us. It's proven to work very well within including difficult environments, and obviously the parties are familiar with it and accepted it. But based on that, also the World Bank can make a objective assessment that in fact the contract itself demonstrated that there was a non-compliance. Therefore, the bank makes its own independent decision to disqualify contractor. And we took it, as I said, not from the point of view of, let's say, punishment, or like more like the debarment for corruption, although it's also something that it is a form of punishment, but more from the form of qualifications, because we see that a contractor that is not complying with this very critical requirement, and there's no doubt that they're critical, because from the very beginning, there is a clear communication, including at the beginning of the contract, when there is a mandatory GBV or SCA, SH conference within the party. So there's no question that this is critical. If the contractor cannot comply with the requirement, clearly demonstrates not to have sufficient capacity in our judgment to be able at the present moment to be awarded under contract. So takes a pause of 2 years, after which has the opportunity to come back, but demonstrate at the time that has in place what it takes to manage effectively these risks and preventing the occurrence of such incidents. It's because, in fact, we have in the contract also a requirement for all contractors to declare whether they ever have been disqualified or suspended, or had a performance security call for reason related to any violation of environmental and social, but particularly SCA, SH. And in that case, there is a additional due diligence that is triggered, which is precisely focusing on the ability of the contractor to demonstrate what they have done to remedy those problems.
Thank you, Enzo. Before I kind of delve into your thinking about using the DAAB mechanism is part of the mechanism, we had a question from the audience. I know that the deployment of this mechanism is fairly new, and a question in the audience is asking, has any contractor or any organization been disqualified yet?
So first of all, because we launched it in 21 for the new contracts, meaning the contract that were advertised on and after January 1st, there's of course a lag between the time the contracts are advertised and the contracts are beginning to be implemented. And so it's really not that that many years, that in fact a couple of years that is in place. But no, we are monitoring very closely. First of all, also we should say we applied initially only to the projects that are assessed at high risk of gender-based violence. So this is not a very large universal project, but those projects we monitor very, very closely. We did not have any incident, in fact, in those projects that I'm aware, certainly not major incidents and no major case, which actually is a very interesting, because one of the objectives of this mechanism was that to be a preventive mechanism, right? It is a compliance-based. We are not, with this mechanism, stepping into the possible underlying facts, right? What happened? That, of course, is the subject of other mechanism and other requirements, and then there certainly is that aspect as well. But this is a contractual compliance check and mechanism, which focuses simply on the rigorous application and compliance with many requirements, which we have included, from a code of conduct to having personnel who is qualified to assist and advise on this, and any other possible requirements that could be in the contractual environmental and social management plans, which could be to address specific risk, training the communities, outreach, whatever is required. They need to do it, and if they haven't done it, the DAAB helps in this dual role, not just the role that is an adjudicator, but also the role of compliance monitoring, which is an ongoing basis during the missions in the field, or documental reviews, or any other way that the DAAB exercises this function in a compliance monitoring mode.
Thank you.
There are quite a few questions coming. Sorry, Aisha, there are quite a few questions coming up. Perhaps we could leave the questions until later. We could continue with our discussion, and then if time permits, we'll come back to the questions.
Okay.
Aisha?
Thank you, Jeff. And so I just wanted, traditionally, the DAAB focuses on compliance with the contract, rather than focusing on protection and social and environmental issues. Why is it that you chose to integrate the DAAB as part of this mechanism in holding contractors as accountable partners?
Because the DAAB was already, as I mentioned, a tool that the FIDIC document, which we use as a standard conditions, offered to us, and it is a credible tool that is, as I said, accepted and actually appreciated by the contractor as well, right? For us, it was very important, and we did extensive outreach to the contracting community and the consultant engineers, but also the contracting community across the globe. Really, we did it in Europe, but we also did it in China, in Africa, and consistently the feedback was that we needed to rely on something that was well established. Right now, it would have been much more difficult to introduce a new approach, a new mechanism, which always requires building a lot of buy-in, a lot of ownership. There is ownership of the DAAB. There are many benefits that you are more familiar than I am in using it, in terms of reducing time and cost overruns, having a much better relation between the parties. So we thought this would be almost a ready tool that we could rely on, but at the same time was an opportunity to innovate and to partner, as we do often with the industry. And in this particular case, I'm really very grateful for Jeff's also help on this, to mainstream this concept of prevention of gender-based violence has a development issue, not just a criminal issue, right? This was the first reaction when we discussed this outside the bank. Well, yes, it's very serious, but it is for the criminal authorities. Yes, that is true, but that's separate. It is also a joint responsibility. So all it goes back to, Aisha, that concept of accountable partners, right? If we're accountable partners, we can together develop building on what it exists, but develop a way to not just deliver good projects, but deliver good projects, with a conscious attention to the risks that this poses to the poor people of the world, essentially, but really the communities that we serve, and we do it in a way that really also goes directly at the heart of what procurement is now, which is not just to deliver results with economy and efficiency, but with value for money, which is a concept that includes sustainability and includes prevention of GBV, includes creating communities that are really open and accessible, and again, it is a policy objective that is way beyond what procurement used to be. So all this is a long way to say that this was an ideal way to build on something that existed and partner with industry to reach objectives that are sustainable.
Thank you, Enzo. You mentioned the word which struck me was criminal. Some people who are participating here today might not know the mechanism very well, but so if I explain very quickly, under the special provisions which you use on these high-risk projects, the dispute board, the DAAB, when they make site visits, must ask about the contractor's obligations with respect to prevention of the GBV, or a GBV, gender-based violence. And if they become aware of any potential non-compliance, either from their visit or from the engineer or the employer, then they put that in their report, their site visit report, and then the employer is, with the engineer, obliged to investigate and, if necessary, refer the matter to the dispute board, DAAB, for a decision. And it's following that decision that you go on to decide whether to disqualify the contractor or his subcontractors. Now, in that mechanism, isn't there a risk? Might not some DAAB members feel at risk of being drawn into criminal proceedings? Are they not being asked to do the job of the police, the local police, or the local courts, with all the problems that might create?
Well, first of all, as I said, that we are very careful not to require any investigation or any even check. In fact, even there have to be not necessarily facts, right? There could be an incident that also trigger, but that's what happened and whether the incident has a factual basis or not. It's completely irrelevant for the compliance check. So really the compliance aspect is completely divorced from what happened or could happen. We are all focusing, as I said, on the prevention and to have in place what it takes to mitigate and prevent the risk of SCA/SH. Second, the contract itself, it's self-regulating, right? So there is really no, although there are some aspects of domestic law that may apply, but there's no other requirement from domestic law for the contract to function, right? Of course, the criminal potential proceedings are completely separate. So there is really no particular risk, in my view, that the member of the DAAB may be thrown in the criminal proceedings, because in fact it will be not even known who the victim or the survivor is, because, as I said, survival confidentiality is one of the key requirements to ensure that this survivor-centric approach is maintained also in the procurement approach. So the DAAB member will not know if there was or who was the survivor, will not have any specific information on the incident, and will not in any way review any aspect related to a potential incident. If there was an incident, it will simply review aspects of compliance. For example, there was supposed to be a training of the personnel, including certain aspect that was part of the contract documents, and that was not done. Or there was, certain elements of the code of conduct that were not there, or that maybe in some communities that are remote, that are to be posted. And whatever it is, a requirement has to be checked. Of course, the questioning, the review, I would call it, not investigation, will focus on those things, but will not touch in any way the elements of a possible incident. So I think the two things are completely separated, and there shouldn't be any worry that the individual may be drawn into criminal proceeding. It will have no knowledge to share.
Thank you.
Thank you for that explanation, Enzo. And I think what this conversation with you is revealing, that this is a new and possibly novel concept. I mean, we're going from, you use the term, this is a development issue, not a criminal issue. We talked about accountable partners. We talked about, you were focusing on building societies, not just building bridges. And this is a development issue. This all brings to the fore the communication of information and communication of the mechanism, and going back to capacity building and making sure people understand the mechanism, why it's there, how it's used, and what it's not. So we're aware that the World Bank has done a lot of internal training for its own personnel. We at the DRBF, for the first time, because of all of what was just discussed, we are, for the first time, Jeff and I are pleased, along with our colleagues from DRBF, to announce that we are going to do a workshop in Nairobi, Kenya, to introduce the mechanism and provide detailed training on the role of the DAAB in this particular process, not which is, like you said, it's a normal mechanism in the FIDIC contract, but it's being deployed possibly in a unique manner to assess contractual compliance with very specific provisions. But that being said, might you consider that specific training is required not only for the DAAB members on high-risk projects, but and your borrowers, but also for government staff, consulting engineers, contractors, and subcontractors? And if you could just comment on that aspect, we'd appreciate it.
Yes, so we have, first of all, carried out a significant training of our staff. As you mentioned, we've been partnering with FIDIC also, as well as the DRBF, to prepare and deliver seminars for the industry, including consulting engineers, and also our colleagues on the ground, and particularly led by the procurement managers. We have 8 of them that are working in the different regions of the bank, have also delivered significant sessions to borrowers, and in particular at the project level, right? Because there was a question I saw also, how many are the projects that are at high risk? There are not that many. I mean, there are maybe between 10 and 20 at this moment. I think around 20. I don't have the precise number, but they're not a huge number. But in those in particular, consistent with our risk-based approach, we focus a lot more on ensuring that the staff is appropriately trained, is fully aware of this. And in addition, our supervision and our hands-on support in actually applying this, at least to ensuring that the contract has all the elements and the contract is also managed appropriately, because now we can do that more extensively than before in terms of hands-on support, of course, without crossing the line. So those projects have all being including significant training and assistance to the borrowers to understand and apply this correctly. And that's perhaps why we didn't have incidents. I like to think that the preventive nature has worked, which would be the best, right? We're not looking at disqualifying, we're looking at preventing SCASH. That's the objective.
Prevention
Thank
is
you.
certainly better than cure.
Exactly. I think there were some question that I may have missed. I would like to make sure there's
There are quite a lot of questions, Enzo. I don't think we'll have time to do
but there was
more,
one that I
but
think
if you have a
Anna
few minutes.
asked to go back to, and I missed it. There was one in particular that Anna had asked that we could revert to, and I
Yeah, there's one in the chat where let me find it. Why the monitoring of the compliance is not imposed to the supervision consultant, but to DAAB. Eventually, the supervision engineer is the prime party to ensure proper monitoring over the quality of works and performance of the contractor. Didn't you think that the authority of the engineer would be bypassed?
That's actually a very good question. Certainly, the engineer has a role in this and a responsibility, which, by the way, we're looking at with FIDIC to monitor and strengthen as much as possible, because, in fact, in the cases where we had the problems, did not work as well. But the idea was exactly not to bypass, but to add a mechanism that would further strengthen the ability of the contract to mitigate this risk and prevent this risk by including this more independent mechanism, right? Because the engineer, of course, is independent engineer with a capital E, but it's still a part of the employer, right? That's technically. While the DAAB, truly, as you know very well, the way it's established, it's based on the agreement between the parties, and the requirements for the members of the DAAB, in fact, are quite stringent in being not from any country of the borrower or the contractor, to be certified, follow a certain process. They're selecting from a particular list, and the World Bank has to agree to the one that are proposed by the parties, as you know, the process for proposing them, and we do have to agree to the list that are so it means that there is a level of quality control on the independence in particular, and the technical qualifications of the member of the DAAB, which adds another layer. I'm not saying that the engineer is not important, but we have a lot more let's say, involvement in oversight of the DAAB. And again, it's a perhaps an even higher level of independence, which together with the engineer should help us strengthen our ability and the borrower's ability to prevent this risk.
Thank you. The two related questions, Enzo, related to the engineer's role, which have come in. One says, is disqualification applicable to the employer's engineer as well? And related to that, incidents can be caused by the supervision staff as well.
So that's a very good question. Now, at the moment, the mechanism exists for contractors and subcontractor as well, who may have been involved in the may have not complied with their obligations. We have not extended to the engineer because it's more complex. It's of course a different contract as well with the engineer. It's a consulting contract, as you know, not a construction contract, and that would have been too complicated. It's a good question, and it's something we did think about it and consider. I think certainly that's a consideration for what is the accreditation and the qualification of the engineer. So it's a conversation that will continue with FIDIC.
Okay, thank you. Going through the other questions, I see that most relate to the details of your standard procurement documents, where you set out the mechanism and you set out the role of the DAAB. Well, as our time is up, we're not going to be able to address all of those questions, I think, now. But what I could suggest is that people register for the training, which we will be giving in Nairobi in July, when we will be looking at the mechanism in detail, the requirements of the contract or your special, your standard procurement documents, which include this provision. The details of the training course are being circulated in the chat. So everyone would be welcome to join us in Nairobi to learn more about the mechanism and the DAAB role. So
I think, Jeff, you and Aisha are certainly the world foremost expert, much more knowledgeable than myself on this. So you'll be able to answer the question. However, I can also offer, if you would like to collect the questions and send it to me in writing, I would be more than happy to send a brief answer for each one of them. That's my take on it, and then you can share those with the participants, or share it at the workshop. So happy to stay involved and help any way I can.
Thank you very much. That would be very helpful. I'm sure we'll take that offer. Thank you. So I'm sorry we have to end now. We only scheduled this for half an hour. Perhaps we should have been a little bit more flexible and allowed more time for questions. But thank you very much, Enzo, for giving up your time to make this presentation, to give us this information. I'm sure everyone will appreciate it a lot. And I thank everyone who has joined us today. As Enzo has said, we will try to answer your questions in the next few days. So if you want to know more about it, join our training session in Nairobi. Thank you.
Well, thank you very much to you, Jeff, Aisha, and the DRBF, and all the members for this partnership, which for us is critical. As I mentioned, it's a critical partnership to really help deliver on a major priority for the World Bank.
Thank you.
Thank you very much, Enzo. Thank you, Jeff.
Thank you, Aisha. Bye-bye, everyone.